I want to answer a question that we get quite a bit, and that's about what's the process that a person should go through if they discover that they purchased a home that was subject to fraud. In other words, if you buy a parcel of real estate and you then realize that it's not the way that was represented, what do you do and what does the process for getting your money back look like? And so the very first part of the process is going to be you move into the property and realize that something about it isn't the way it should be. So it could be that you move in and discover black mold during your remodel. It could be that you move in and then 2 weeks later undisclosed construction starts blocking the view. It could be that you move in and then realize there's a massive problem with the main water line. From my experience, I can tell you, when people move into a property and are sincerely surprised at its condition, that typically means that there is a valid case of real estate fraud there, and there is a remedy and there is something we can do about it. Once you do that, you're going to want to call a good, competent real estate lawyer, and you're going to want to make an appointment to speak with the client relationship specialist. That person's going to tell you about the firm, they're going to talk to you about your problem, and they're going to talk to you about what you're experiencing. Sometimes this fraud affects people financially, and some of the financial concerns that people have are some people are concerned about the cost of fixing whatever's wrong with the property. In some cases I've seen, particularly black mold cases, you can have $50,000 or $100,000 or even more in renovation costs to fix what the seller lied about. Sometimes people are concerned financially in terms of how it'll affect their property value. There can be times when your property value initially is $100,000 or more diminished because of the lie, but it doesn't end there, because if you're planning to hold the property for 5 or 10 years and it's enough time for the property to double or triple in value, that $100,000 diminution in property value can be $200,000 or $300,000 worth of loss by the time you ultimately sell it. Other people are concerned financially about the amount of money they've already spent. Perhaps they've already spent $25,000 or $50,000 renovating the property before they've moved in. All those are financial losses that are recoverable if you've been defrauded. Other folks are concerned about time. Sometimes they're concerned about the amount of time that they would have to live in the house that's not to their liking. Some folks are concerned that they can't effectively spend time with their family. One thing I've noticed, particularly among my clients who are divorced, is that if the property condition is bad enough, that prevents their kids from living there. And so then the other parent winds up getting more parenting time, even though that's not really what the court order says, because you've got somebody who just has a property that's not safe for the children. Other concerns that I found people have relate to their relationships. I've seen cases where the property was uninhabitable and people were concerned that, the partner they were living with might move out on them. People have been concerned that they won't be able to have their friends over as guests in their home, and it's going to affect their relationships. Whichever of those concerns are most important to you, it's important to think through it and think through everything that you have to lose if you don't adequately solve your problem. And our client relationship specialist can help you think through how all of those things apply in your case, and they'll also help you think through the value of getting the problem solved. Once you get signed up with a lawyer, first thing you're going to want to do is send out a demand letter. And the demand letter has to meet special requirements that are promulgated by the Arizona Association of Realtors. You're going to want to make sure you initiate mediation, and there's a special form you have to fill out to do that. And you're going to want to make sure you pick a good mediator. Mediation of these types of fraud cases in Arizona typically needs to be done in front of somebody who's on a small list promulgated by the Arizona Association of Realtors. And you're going to want to make sure that whatever law firm you choose, they're familiar with the people on that list and they know which ones are going to be best for you so that you can get the best deal and have the best settlement possible. Once that gets sent out, typically what happens, sadly, is sellers need to be chased down a little bit before they're willing to mediate. A lot of times what happens is sellers will hire a lawyer, and before they actually agree to mediate, they'll say, well, hang on, we need to figure out whether or not to mediate. It ought to be pretty obvious, but a lot of sellers, they create some delay doing that. Once you do that, you need to turn in your form to the mediator to get that started. And so typically the way that's going to work then is a mediator is going to have what's called a pre-mediation meeting with the lawyers or the parties on each side. If you have a lawyer, you don't even need to worry about attending that. Your lawyer takes care of that for you. And what they do there is they schedule the mediation, and then they schedule a time prior to the mediation to turn in something called a mediation memo. So between scheduling the mediation and doing the mediation memo, what your law firm is going to do is work for you to make sure that we are adequately documenting how to win your case and also what your damages are. You'll be contacted by paralegals or attorneys from your law firm, and you're going to be assisted in coming up with the maximum possible amount of damages for your case, and also compiling all the evidence that you need to show that you have a good case so that when you get to mediation, you can have the best possible result and really show the other side that they need to settle because otherwise they're going to wind up losing. This gets written up into what's called a mediation memo and submitted to the mediator. The mediator often will read it and ask the lawyer questions about it between receiving the memo and the mediation. And then you're going to get to the mediation day. At the mediation day, you're going to start with the mediator, and the mediator is going to sit down and have a very long meeting with each side. The mediator tries to learn as much as they can about each side's case. Sometimes they have a list of questions based on the mediation memo. They also are going to attempt to engage with the parties on each side and tell each side that they think their case has weaknesses. And so after you finish your meeting, typically the mediator is going to spend 30 to 60 minutes with the seller. You're going to basically have some downtime there with your lawyer. I often recommend to my clients that they bring a book to mediation just because there's going to be that much downtime. But then the mediator is going to come back, and typically we ask the mediator to come back with an offer from the sellers. Now, the initial offer is often not anywhere where we're going to wind up, and the mediator is going to really try to get you to take that offer or at least make a counteroffer near it. It's very common for mediators to more or less tell folks that their offer is too high and essentially try to have the mediator get the party negotiating against itself. And whenever you're negotiating against yourself, you're losing. So you really need a lawyer who's going to have the courage to tell that mediator no. Then you're going to give back the offer that you've already prepared with your lawyer, and you're going to send that back to the other side and try to settle there. Typically, about 2 or 3 rounds in, you have a pretty good idea whether you're going to settle or not, and you continue exchanging offers until you get down to a final number. The mediator is going to have at least part of a settlement agreement prepared, and you're going to want to memorialize the key terms of that settlement in a signed writing before you go. After that, the lawyers are going to flesh out a more comprehensive scope of release and settlement agreement, and once that's all done and signed, you get paid. And then you get to take that money and you can use it to repair your property or buy a new one or get into a house where you can safely live with your family. And that's how you won. So in a nutshell, that is mediation in Arizona.